So let me introduce myself. I'm David Lehman. I'm with K&L Gates. And some of my colleagues that are on the phone, my partner, Oded Green, Wave Oded, he will be doing part of the presentation on the subject of B corporations and benefit corporations. Jeff Locker, who's on the line, another colleague of mine, he will be joining us for the, we will be popping in and out of the rooms later, and he'll help with that. And Tammy Mack, who I think was going to be here a little later, will also be here. And as Kit said, I'm going to start. She said the word lecture, and I don't love that word. So let's use a different word, which is a discussion of startups. But the idea will be that we'll talk a little bit beforehand, and then we'll break up into the groups. And in that group, we will create what we call the legal roadmaps, and we'll talk about that in a moment. The whole purpose of this is to help startup companies when they first go to lawyers and they think about that startup. We call it creating you becoming a better consumer of legal services, which is you've thought about a lot of the issues before you get there, and you've talked among yourselves about some of these issues. And we find that to be incredibly helpful, and frankly, you'll find it incredible because you'll be talking about these things and hashing it out a little bit. So today we're going to talk a little bit about that. We're going to talk about choice of entity and why you create an entity and which one you would create. That'll be part one. Part two will be the founder arrangements, which is sort of, who are the founders, how much they get, making sure that they own what they're supposed to own, think about vesting and restricted covenants, non-competes, non-solicit, those kinds of things. And then we'll talk a bit about the operation of the entity, the governance and employee equity and what you give employees and that kind of thing. So those are sort of the three buckets that we'll talk a little bit about. And then after that, we'll do the legal roadmap. Let me give you a couple sort of things here on the legal roadmap. Let me just do something here because I can't even see this. I'm sorry. There we go. On the legal roadmap, it's not legal advice, which is to say, this is I mean, this is about the law students are here as sort of to give you ideas. We're not your lawyers. There's no privilege. There's no attorney-client privilege. So don't tell us confidential information. There's no confidentiality agreement. And again, they're intended to help you thinking about it before you get to the lawyers. So that's the objective. And we'll talk for maybe about another 40 minutes or 50 minutes or something, and then we'll break up into the groups. And frankly, those groups can visit afterwards as well, I think. So we're not limited to this evening. Questions before I move on? And I should also make the comment that you should feel free to interrupt me along the way, because if I just sit here and ramble, this will be amazingly dull. Questions? So on hearing none, on the choice of entity, here I have on the screen the sort of the kinds of entities that one can have, and as you can see, there's a wide variety of them. And we will focus on what's called C corporations, S corporations, limited liability companies, benefit corporations, and B corporations, and I'll explain why in a few moments. Let me do a little nomenclature before we start, because we talk about corporations and limited liability companies, and just to make sure we're on the same page. They're both entities. They're both types of entities that you can create. The owners of corporations are called shareholders. Everybody knows this, but let's just be clear. The owners of limited liability companies are called members. So the similar, just shareholders in the corporate world, members in the limited liability company world. And the corporation, you probably know from the rest of the world that corporations, the shareholders appoint the directors, and directors appoint officers. In the limited liability company world, that instead of a board of directors, you have managers. So owners, members appoint managers, just so we are all on the same nomenclature. Similar kind of thing, but different kind of entity. And here's the most telling of all these slides, which is, people always ask me what kind of entity is the very first thing before they give me any other facts. And I always say it depends, because there's a lot of factors, and we're going to go through some of these factors. I will also tell you that I have about 100% experience level of being wrong. If I form an LLC, then later down the road, investors say, oh, you should have been a C-corp. Why aren't you a C-corp? If I form a C-corp, then the people down the road say, why aren't you an LLC? So, and we'll talk about the fail-safe if you can't decide which way to go. Let me start with why form an entity. And the principal reason and the most important is that it's to limit liability. I mean, what a great system where we can form an entity and you are not personally liable for the debts, obligations, or of the entity. So if I form David J. Lehman Inc. and I start selling widgets, nobody can sue me personally for selling the widgets that come out of that company. I only, as a general matter, the only thing people can sue, and the only way we're liable, is for what's in that company. So that's kind of a cool concept, and it's not intuitive. So one just needs to remember. I always analogize it to sort of playing blackjack. The good news is that, and I do like to play blackjack, similar to my guessing on whether it's an limited liability company or a corporation. I always lose at blackjack as well. But the point behind it is that the dealer can't go, he can only go after what I put on the table, on that blackjack table. He can't go into my wallet, he can't go into my bank account, he can't go ask me for more money. He can only take what I put on that blackjack table. Or similarly, the only thing that anybody can go after as a general matter is that which we put in the corporation. That's really important. One of the rules of getting the benefit of that is the second line here, which is that not allowing people to pierce the corporate veil. And what that means is that you would have to adhere to the formalities of the entity. So if you form a corporation or a limited liability company, you got to sign things on behalf of that company. You got to keep a separate bank account and not intermingle your personal funds with the corporate funds. You can't, you have to act like that entity, like it's a real thing, a real entity. And if you do that properly, keep the minutes of the shareholder meetings and board meetings and all that good stuff. And if you do all those things, then if there's a problem, then people can't what's called pierce the corporate veil or sue you or the owner personally for the obligations. Really worth. I realize I'm harping on this, but that's important because it's the whole point behind it. There's ways to limit liability of the corporation or entity itself. You can contractual limitations. So we enter into a contract with people. You can limit the liability under that contract to third parties, and that's worth doing. You think a lot about insurance, making sure you have adequate insurance to protect your entity. But those are ways to protect the entity, so you limit the liability there. There are some things that just worth thinking about on the personal side. And again, I think hard about personal liability versus corporate liability. And so one easy way to expose your personal assets to the liability of the entity is to sign a guarantee. So, and people do it. I mean, if you go to sign a lease, sometimes the landlord will ask you to sign a personal guarantee of the lease, and that's okay as long as you know you're doing it. So think hard before you sign guarantees. It turns out that if you have employees and you don't pay them, it is, at least on with respect to wage taxes and sometimes for wages, officers and directors can be liable for unpaid wages. So make sure you pay employees and you pay withholding and you pay taxes. And some of these flow through things we're going to talk about on flow through tax. There's some potential personal liability for taxes that we'll talk about in a few minutes. But so point one is form the entity, adhere to the formalities, and let's limit our liability. I just went through that so let's keep going. So one of the, and I apologize for those of you that we're gonna talk about tax for a moment, and there's just no way around it. We got to talk about tax for a moment. And there's corporations, C corporations, have what's called double taxation. So if a corporation makes $10, it pays tax on that $. It is a taxpayer. And when it distributes that money out to its shareholders, the shareholders pay tax. That's a dividend, so they pay tax. So you pay tax at the corporate level and you pay at the shareholder level. That's called double taxation. Now the good news is right now, tax rates are a little less than, at least on the corporate level, than they've been traditionally. But the point is double taxation. That happens, that has an effect in two situations at least. One is if you make money and you go to distribute to the shareholders, again, you pay tax on the corporate level and you pay tax at the individual level. And when you sell the company, if you sell the assets, the corporation pays on the assets, and would distribute out the shareholders pay tax. I'm going to give you an example of this in a moment so that it's a little more clear. Let me contrast that with an S corporation, a limited liability company. They don't pay tax. That flows through to the shareholder or the owners. So, for example, in a limited liability company, if it earns $100, the limited liability company doesn't pay tax, but that $100 goes into the member's tax return. So there's only a single layer of tax. Okay, a limited liability company or S corporation don't pay tax. It gets flowed through onto the tax return of the owner. Let me give you an example. So let's suppose that we have our C-corp, which again is the double layer of tax. If it sells its assets and makes $100, it pays a 21% tax rate, $21, ends up with $79. And then it distributes that $79 to the shareholder, who pays tax at $16. So the shareholder ends up with $63. Okay. Now contrast that with my flow through, which a limited liability company sells its assets, again, doesn't pay tax, flows through onto the tax on the tax return, pays $20 at that, and so $80 left over. So the difference between being a limited liability company and C corp saved the person $17 or 17% in that case, if it were bigger numbers. That's pretty important, right? Now there must be something on the other side of this as to why people do C corps, but it's important to make a decision. So the bottom line there is that there's a double layer of tax, and when thinking about C corp versus LLC, think about double layer of tax. So why would anybody do a C corp, right? I don't know. Oh, well, there's a couple of reasons. There's actually a tax reason to do a C corp, and it's the qualified small business benefit that's referred to here. And I always joke that people spend a lot of time trying to think about capital gain treatment or ordinary income treatment or whatever, but there's this wonderful thing, which is that if you qualify under Section 1202 of the code, and there's some requirements, you have to hold the stock for over 5 years. It's got to be certain kinds of real estate businesses, most of which you guys would qualify, I think. And all those things, and you buy it from the company, then there's an 100% exclusion from capital gains. So let me say that again, 100% exclusion. And we have used this just recently. We've watched this on a couple of transactions that we've just closed in the last couple of months, where people have really enjoyed this benefit, which is that we're selling the company, selling the stock of the company. They've held it for over 5 years, in one case for 18 years, but that just goes to show how old I am. And they've paid zero tax. I'm sorry to report that it's only good for the first $10 million. So after that, you got to start paying tax. So I'm sorry about that. But so that's a pretty good thing. So if you plan to, hold the stock for over 5 years and grow it, it's worth thinking about a C corporation. There's some other small tax benefits to this. You can do tax reversions in a C corp that you can't do with an LLC. So that's sort of a benefit, but that's not really worth spending a lot of time on. So yes, I got to get rid of this thing. 1 second. Give me 1 second. 1 second. There's also, you hear a lot about S corporations. And so let me spend one moment on that. S corporations are the same. So there's limited liability companies, there's corporations, and there's S corporations. S corporations are are a corporation, just like a C corporation, but it's taxed differently. It's taxed very similar to an LLC with the pass-through treatment. And the benefit to it is it's very easy to form as an S corporation. It gets the pass-through treatment. It's the kind of thing you're used to. But there's some requirements for it. It's a single layer. You can only have one class of stock in an S corporation. There's a limitation on the number of shareholders, which you see there. You can only have individual shareholders and only citizens or residents of the United States. So it's a fairly narrow kind of entity to have. But as an example, there's lots of companies that, for example, run restaurants or something like that, or relatively modest businesses, which don't intend to grow real fast or whatever, or take in additional shareholders or have venture capital or whatever. Then an S corporation is worth thinking about. So that's the alternative there.
David, on your, excuse me, if I can interrupt, on the screen,
Please.
and right along where the title is, I see slideshow, resume slideshow. It's blocking, it's covering up part of your header of the title of the slide. So all I can see is or patients.
Yeah, so that's what I was trying to get rid of. 1 second, let me just play with this for a second.
Okay.
Maybe I'm gonna try this again. Give me 1 second.
If you click on the little X, it should go away.
I don't know if you can do that if you're in the, yeah, there you go. There you go.
Thank you.
While you were doing that, David, I was going to ask you to just expand on why early stage companies that are thinking of growing quickly with other people's money should not consider starting an S route. I mean, S-corp is fine for lifestyle businesses, but if you have an idea about raising outside money, you really only two options are LLC or C-corp. Can you just?
I mean, you're absolutely right, Don. I mean, if you're taking other people's money, an LLC as an S corp won't work. And if the principal reason, there's two principal reasons. One is that there's a single layer. There's only one class of stock permitted. Generally, you can have voting and non-voting, but basically one class of stock. And often, when you take in additional capital, they want you get preferences and give different classes of stock. That eliminates S corporations. Second, the requirement that you only have individual shareholders often eliminates some investors because sometimes they're partnerships or corporations or entities. So as a general matter, if you're taking other people's money, you just rule out an S corporation, injured LLC land or C-corp. And let me make it even easier. If you're heading toward a venture capital, then go straight to C-corp. Do not pass go, do not click 200. Because venture capitalists will not invest in LLCs for some tax reasons that drive them. And so if you're leaning toward you think you're going to do one of the sort of high flying, raise lots of rounds of capital, go to VCs, just go straight to C Corp, do not pass go. It's also IPO. You can't take a limited liability company public. So if you're heading toward an IPO, again, C corporation is the way to go. If you're doing option pools, again, corporations are easier. You can do an option pool in LLC. It's not easy. So those are some of the reasons, some other factors besides tax that I already identified. Let me make one other comment, which is that if you're undecided on what kind of entity to be, which, as I say, we often are, then if it is relatively easy to go from an LLC to a C Corp. That can be done in a tax-free manner, which is, the conversion is relatively easy. On the other hand, going from a C Corp to an LLC is a no-no. Thou shalt never go from an LLC, from a C Corp to an LLC. I'm not sure, but I think that's the 11th commandment. You're just not allowed to do it. And from a tax perspective, it is a taxable event. And so it's a real problem. So if you really can't decide, start with an LLC and then convert to a C Corp later. And frankly, that's a strategy that many companies use. And in part because investors, some angels kind of like it because in the LLC they can use the losses, and then you convert to a C Corp later. And so sometimes that's attractive to people. So that's something worth thinking about. Don, did I answer your question?
Yes, thank you, David.
David, we have one question in the chat. Is
Yeah.
it possible to have a C-corp as a VC, as a holding company and an LLC under it so as to avoid taxation for the shareholders?
Good question. Very creative. No. So, and the reason that that doesn't work is that, well, actually, the way you described it, absolutely not, because it will flow through. If you have the C corp own the LLC, then it will flow through to the LLC, and all that income will get trapped in the LLC. So you'll end up in the same place as the C corp, as it had the C corp. The more interesting way to do it is have the LLC own have an LLC which then owns the C corp, and then do the business in the C corp and have the VCs in there. But that really hasn't accomplished anything because you still have the double layer of tax. So it's a creative structure. I'm not sure it's going to get you where you need to be. I think this is a either or. But that was a creative thought. You have a future. Call Oded when we get done because we want to give you a job. Yes.
There was a question about whether it's possible to go from an LLC to an S-corp.
Yes, actually, interestingly, you can not only go from an LLC to an S-corp, but you can actually be an LLC and tax like an S-corp without even actually converting to an S-corp. So if you wanted to be taxed like an S-corp and be an LLC, you can actually do that. And there's some obscure wage tax reasons that sometimes people do that. But the trouble with that is that you're still stuck with the restrictions of the S-corp, of the single layer of tax, and restrictions on shareholders. So just beware of that. But the answer is yes, you can go from you can either be taxed like an S corporation if you're an LLC or convert to an S corporation. Either one's fine. We can do that. Good questions. So there's no, it goes back to my, it depends, but there's no simple answer. And I said, I'm always wrong. But if you're thinking about a lifestyle company with, then consider an S corporation or an LLC. One other LLC reason sometimes I do an LLC is what I call the mini liquidity event, which is if your business is going to be a technology which you're seeing a lot of called mini licenses. So you have this great technology and you want to license it out for a variety of things along the way and distribute those. That's a wonderful thing to have in an LLC as opposed to a C corp. And we've had a client or two that have gotten trapped because they were a C corp. And that's a model where you actually want an LLC. So if that's the kind of model, stay in LLC land. If you're heading toward venture capital, go to a C corp. If you plan to hold it for 5 years, consider a C corp. And remember easier to go from an LLC to a C corp. Let me switch over to Oded and let him talk about benefit corporations and B corporations.
Thank you, David. Real fast, before we move on, I had one question. You showed an example of the tax implications of the LLC. Is it similar if there's a multi-member LLC, or do you pretty much cut the numbers in half when you go to do your tax returns at the end of the year?
David, you're on mute.
Somehow I got pushed off there for a second. I went
You
into,
did, yeah.
accidentally. I went into one of the breakout rooms, bizarrely.
Yeah, sorry, I accidentally hit the button, but I closed it, so we should be good.
Oh, okay. All right, cool.
Sorry.
I thought it was like being in Star Trek and I got beamed up somewhere. Okay.
I thought you were just
Sorry.
standing by the question.
Yes. So what was the question? I'm sorry.
Yeah, so you showed a side-by-side of tax implications of a LLC versus a C corporation in the breakdown of the double taxation or single or pass-through taxation. But when you have a multi-member LLC, are you and your partner paying taxes on the total net gains, or is it, since it's a multi-member, do you kind of split them based off of your percentages, and that's the percentage that you're actually paying your taxes on.
Good question. It is you have the right answer, which is that you pay your proportionate share. So if you're 50-50 members of a percentage ownership of an LLC, limited liability company, and then you each pay 50% tax on 50% of the income. 50% of it ends up on your tax return.
Thank you.
Okay. All right, Oded, let me see if I can share my screen again.
Okay.
Let me try something else here. 1 second. Let me see if I have. Can you see this one?
No.
No.
What can you see now?
Well, it's starting to share. Oh, and we've got the full presentation.
Got the full presentation? What do you got? Structuring startups?
Yep. So you're back at the title page. So you'll have to fast forward to Oded's part.
Yeah, 16.
How's that?
Yeah.
And the reason that we have this problem with the presentation, Dave and I always get confused when people start talking about non-for-profits, profits, it always confuses us. We know, and that's a traditional approach, that companies are either for profit, that's one part of the universe, and the other part of the universe is non-for-profits. And if you're gonna be a company, let's say GM, Ford, or something like that, your sole purpose in life is to take care actually of making profits for your shareholders to maximize the profitability for them. So if you're Bill Gates, for example, and you hold Microsoft, you cannot use Microsoft as a tool to take care of the benefit, let's say, of the environment or curing cancer in Zimbabwe. But you can do separately from that as an efficient tool, you can create as Bill Gates himself, not as Microsoft, a non-for-profit that will take care of that. So over the years, the lines between the for-profit and the profit the lines have blurred. And many companies have been engaged with a little bit doing for the public benefits. And on the other hand, you can find non-for-profits, like, for example, UPMC, that they make a lot of money although they are non-for-profits. So in recent years, there's been a really strong trend towards combining these two. A few examples is Ben & Jerry's, Patagonia, and other companies that wanted to add some public benefit to their goals. So it's a for-profit entities that their whole they have a purpose of making profits for the investors, but also doing something good for the benefit of the public. And a terrific one of our favorite examples is a Pittsburgh grown company called Thread. And what they're doing is recycling or collecting, that was their traditional or the original business plan, was collecting plastic bottles in Haiti and other troubled countries, converted it into fabric, and then subsequently either sell this fabric, companies like Nike, for example, or create their own fabrics here in Pittsburgh. And they're actually funded by venture capitals on the one hand. On the other hand, they're also funded, you can see by foundations that give them money because they say, hey, this creates opportunities both in Haiti but also here in Pittsburgh where they produce their fabrics. So around, I think there are, and Stephanie would probably correct me, but as far as I know, that there are 38 states in which there is what is called benefit corporation statutes. And if we look at Delaware, for example, so they define the benefit corporation as a for-profit entity that intends to produce a public benefit and also to operate in a responsible and sustainable manner. And it creates, each company has its own purposes in life, and it can be generally for the public benefit or for specific purposes, for example, the environment. From a tax perspective, because they've talked about it, and it's important, it can be either an S-corp, or it can be either a C-corp, it can be a partnership, it can be an S. From tax perspective, they you don't have a benefit. The benefit corporation doesn't give you any benefit from tax. It can be any type of entity that you choose, actually. So why do people do this? What are the benefits, and what are the advantages, and what are the disadvantages? So we saw it with a couple of companies. It's a great marketing tool. If you want to use it not only as a strong commitment to the social purpose, you also want to use it as a marketing tool, exactly like Thread or Ben & Jerry's. You say, hey, take my ice cream, buy my ice cream, but it also will benefit the environment, will benefit XYZ. That's important. There's the strong commitment to the social purpose that you want as a founder, that you and your co-investors want to contribute. It provides you also the legal protection, because if you go to GM's board of directors and you want to say, I want to devote, I don't know, X% of our revenue to doing good, a substantial amount, let's say, of your revenue, then you'll have a problem as a directors, because you don't fulfill your role in life is to maximize the profits of the company. It also gives you the flexibility if the company is being sold tomorrow. If you want to devote, make sure, for example, you want to sell it to specific buyers that you'll know that they will be good for the environment or for your cause, then you can choose whoever you want. But if you're a Delaware corporation, you cannot do that. Your job in life is just to maximize profits. So what are the disadvantages? And this is important, because it's not only good thing about it, but it also there are problems. If you're an investor, if you're a VC, for example, you will feel, you may feel discomfort when you go, people ask you to invest in this kind of company. Why? Because you're not, it's good to do for the benefit of the public, but you got your own responsibilities and obligations to your own investors. So not everybody will be inclined to invest in this kind of companies. On the other side, on the flip side, you can find foundations that would love to invest in this kind of an entity. I'll just give an example. I think there was a guy that did something related to education. So this actually may be an attractive for foundations, there are VCs that invest solely in public benefit purposes, not necessarily corporation, but with a commitment for specific things. So generally VCs won't like it, but there may be specific foundations, specific entities, or specific investors that may actually like it. Now, this is a new creature of the law, actually, and there is a lot of legal uncertainty. How is the company supposed to act? How should the directors act? More importantly, once you're on board for this kind of a venture, you have to remember that there are obligations. You have reporting, and it can be tedious. There are disclosure requirements. So that's an issue that you need to take into consideration when you do that. It's a commitment. It's not something you can say, hey, I'm just a benefit corp. Finally, there's no tax. There are no tax incentives for this. It's just like another corporation, as opposed, for example, to non-for-profit that has substantial tax benefits.
Oded, I have a question.
Sure.
If you're a benefit corporation and a foundation is interested in providing some funding, do you still need a fiscal agent? Can the foundation go directly into the corporation? Usually there's a fiscal.
So let's talk a little bit. I'll give you an example. RK Mellon. RK Mellon invests in companies that have a goal for the society or a specific purpose. So they would love, they may love actually a benefit corporation, but the benefit itself, the benefit corporation itself doesn't give them any advantage. It's the same from their perspective. It's a corporation or a benefit corporation. From their perspective, it's the same beast from their perspective. And the same requirements would apply to both the corporation and to a benefit corp. So I've seen the foundation invest in a benefit corporation as long as it's aligned with their purposes, but they also may invest in a regular corporation.
What? But even for the corporation, I was under the impression foundations cannot give money directly to the equivalent of a for-profit organization. You need a fiduciary agent in between that the foundations give the money to the fiduciary agent, and that fiduciary agent then distributes the funds into the company.
So foundation, I'm not an expert in foundation law, but it's not necessarily accurate. I know right now I'm working with a foundation that invests in a for-profit limited partnership in a fund, actually. They're going to invest directly in that, so it's not an issue as long as the investment is directed for their purposes.
Yeah,
But usually,
Kit,
when
the fiduciary agents are typically involved with the grants, but there's something called programmatic related investments, which foundations are allowed to make investments so long as it's within the mission of the foundation and the mission of the organization. So it would be structured as an investment as opposed to a grant. But you're right, if it was a grant, it would need it typically go through a fiduciary agent. That's a
Okay.
nonprofit.
I can give you two examples that I'm involved. Actually, I was involved. Stephanie was involved. One is a foundation investing in a for-profit. I think it was a for-profit partnership for creating movies. That's one thing. The other thing is, and she smiles, and the other part is, another example is a foundation investing actually in a fund that invests in distressed real estate properties. So that's another example. And both these entities are for profit. It's not that they're benefit corporation. Having said that, it's good for them to present to the foundations, hey, we're really benefit. We take care of our environment and all this stuff. Just an example. And BNY Mellon, they have an arm now that invests, or they call it the socially responsible arm that invests in this kind of businesses, or they coordinate investment of this kind.
But again, those are investments, not grants.
Correct.
so they're taking perhaps a small sliver of whatever their not portfolio, what is it?
That's exactly right, yes.
Okay, and so instead
Yes.
of doing regular stocks and bonds, they'll have a portion they'll deliver. Okay, got it.
So,
okay.
but why don't we take a moment there and just pause, and Oded, I mean, there's also nonprofit corporations, right? And if you have a nonprofit 501c3, then folks who are donating can get deductions and those kinds of things. Those kinds of benefits don't apply to benefit corporations, right? You don't get deductions for contributions to these. You don't get, they pay tax, one way or another, but these are not nonprofits. And so one should not think of the benefit corporations, B corporations or others as nonprofits, because they're not, and they don't get the benefit of nonprofit corporations. So sorry, Oded, I just thought I'd make that point.
Any questions about the benefit corp? Because there is a separate thing called B certification, but any questions about the benefit corp? No? Good. So B certification, and it's called B Corp. There's a lot of confusion. People, and actually attorneys are pretty confused. We see it in our emails that we get from time to time. They want to form a B Corp. B Corp is not an entity. It's kind of a certification that you get from a third party. I forgot how they're called. They're called B Labs. And B Labs gives you a certification that you're qualified as a B Corp. So it's really a nice thing to have. Traditionally, when there were not required, there was no legislation. Let's give an example. In PA, the benefit corporation came later. So you could have a B certification as opposed to being a benefit corp. But today, in those jurisdictions where there is the benefit corporation legislation, as a condition for B Lab to give the certification, which is a higher threshold, you need to be a benefit corporation. So it's a third-party certification. It's not a legal entity. It does not have any corporate or tax benefits. And it has a whole laundry list of requirements. It has to have a specific purpose that corresponds to what they require from you. There are more rigorous annual reporting requirements and other burdens. Having said that, it's nice to have it, and it's a nice thing to show, especially if you're a benefit corporation. Why not use it and if it's not too burdensome for you to become a B Corp certified company. And there's no negative aspects to that, not from the investor side and not from other party side. Let me see, I think there is one more slide here, David. Yeah. So it provides us what is good about it. It provides commitment to social purpose and access. It gives you access to the community of other B Corps, and especially the main benefit is it's a good marketing tools. And the disadvantages we discussed. Any questions? Now it's Dave's turn.
Yeah, thanks, Oded. Let me just, one of the things that, so in the last slide on the issue with sort of formation is what state. If you are, and we just happen to be in Pennsylvania. So to me, the choice is if you're around here is Pennsylvania or Delaware. And my general rule of thumb is if you are going to attract additional capital from venture capitalists or otherwise, I tend to go toward Delaware because people are accustomed to Delaware. It's well respected, the body of law. It's predictable, and venture capitalists are comfortable with Delaware. If, on the other hand, you're going to do sort of you're not doing that, and you're sort of operating in Pennsylvania, and you plan to perhaps only get angels or operate here, then I lean toward Pennsylvania. But that's something you should decide at the time. But if you're going to attract additional capital, I typically just go to Delaware. And you may ask why Delaware, and the answer is because that's where everybody's gone. It's bizarre.
Dave, can I ask a question here?
Please.
So I know that we are, like California, rolling out certain regulations on data security, consumer privacy laws. Were there any concerns for not to incorporate in that state if you're doing certain kind of business?
Well, I think it's a fair question. I think the California issue addresses more of doing business in California, which is less about being formed in California than it is doing business there. So, for example, I mean, you talked about the consumer issues and that kind of thing, which is really, are you doing business there? So if you have customers there, then you got to address the consumer issues in California. Similarly, if you have employees in California, there's a different world of non-competes and that kind of thing. So I think it's, having said that, you raise a good question, and for those reasons, and the rebuttable presumption, sort of a presumption that if you're California, you're subject to California laws. So I would, unless there's a really good reason, I would avoid California as a general.
Thank you.
I don't mean visiting California. I mean incorporating California. California's a lovely place. Okay, cool. Got it. All right. All right, so that deals with part one of what we do, our legal roadmap, is what kind of entity is going to be. Part two, which I'll do a little faster, is founder arrangements. And it's going to go to two parts, which is what I call the roadblocks, and then their relationship with each other. And the first issue is to make sure that our founders have the authority and the ability to enter into this new company. I mean, you're sitting there with your partner, and you want to make sure, okay, can they do this, right? That's part one. And this is a threshold question that I am surprised that people don't ask, and they're sorry they didn't ask later. And so the question is anybody subject to any non-compete or non-solicit? When I sit down with people, my first question is, what are you doing now, and who do you work for? And is there anything that there's a invention assignment agreement to somebody else? And people say, oh no. And then you poke for a little bit more. Okay, well, who do you work for? I work for Google. Okay, and do they have, but I'm quitting that. All right, cool. And do they have an invention assignment agreement? No. Well, maybe actually they do. And when did you come up with this idea? Oh, when I was working with them. But don't worry about it because it has nothing to do with what I was doing with it. But the point is that they may very well have an interest on it. So the question is, does anybody else have any interest in what you're in the IP? Do you have a non-compete with other people? Do you have a confidentiality agreement that this runs afoul of? I have fiduciary duty on there, which is, are you currently a board member of another company that you have a fiduciary duty? So you actually can't go start this company with this idea because you have a fiduciary duty to offer to the other company. So I want to make sure, I call it clearing the founders. Let's make sure that there's no strings attached. The most obvious one for all of us is that a lot of these startups are coming out of the universities, right? They may not even own the IP. It's probably owned by the university. So maybe we got to get it out of them as opposed to another institution. So that's a long-winded way of saying you got to ask these threshold questions. Do our founders have the authority to enter into this deal, assign the IP into the company? All right, now we get it in. Now we want to make sure, okay, well, we know we have the authority. Now, what's the relationship between that founder and the company going forward? Are they going to have are they going to be an employee or independent contractor? Or are they just going to wash their hands of this? They say, look, I'm here as a consultant, or even I'm out of this, I'm putting my IP in and I'm just going to be out, which is okay. But it's good to know that up front and have a frank conversation amongst yourselves about what role everybody's going to play. Really important up front. Are they going to get paid? You see on this thing, it's the intellectual property assignments. It's really critical, which is that when we form the entity, make sure that the IP gets conveyed into the company. You know, there's nothing worse than getting to your VC, raising capital or sale, and turning out that the company doesn't own the IP. You know, that's a little like, you know, having a mortgage on the house and not realize it. I mean, you got to make sure you own the house. You got to make sure you own the IP. Make sure that gets assigned. Really important. You know, we have founders, and I'm going to assume for the moment that we get additional capital. Are we going to impose on them restricted covenants? Are they going to sign a non-compete, confidentiality, non-solicit? There's nothing worse than putting money into a company and having one of the founders leave and then go start a competing company, right? That's in the world of bad things, that's pretty bad, especially if you're putting money in. So are you willing to, if you're starting this company, sign a non-compete that says, okay, I'm not going to go enter into another company, start another company, or work for a competitor for a period of time? Can your co-founders count on that, right? I mean, I'd hate to start a new business with Oded. I mean, forget the investor. He and I, we spent 2 years on this, and then he decides to go start a competing company. That would not make me happy. So do we have an agreement amongst ourselves that there's going to be a period of non-compete? Non-solicit means, are they going to steal the employees or the customers? So is there a non-solicit? We usually try to get these things done. You know, you'll see term and geographical limitations. There are non-competes are generally enforceable in this kind of circumstance, but what's the period of time? You know, 6 months isn't going to do you any good. 5 years is too long and probably not enforceable. So is it 1 year, 2 years, 18 months? I mean, you want to agree on that. So when we do our roadmap, we're going to figure out what's a reasonable period of time for, and what are you going to impose on among each other for the non-compete, non-solicit. And as a geographic limitation, you know, that's sort of an old concept because everybody's all over the world now. But what's the geographic location limitation on it? Then we get to the splitting the pie. And I know you guys have, I know that there's been other presentations on this, and we're not going to spend a lot of time on this, but it is important to think about, okay, so who gets how much? And let me give you a couple of general comments on this, and then we'll go through one example of a process. First of all, remember that there's going to be inevitable dilution. You're going to issue equity to employees, additional capital, et cetera. So whatever percentage you guys start with, it's going to get shrunk over time. And shrinking equity dilution is the fancy term for that. But it just means it's going to shrink over time. So if you each have 25% today, if you give up a whole bunch later, your 25% is going to get smaller and smaller. So that's point one. Point two is keep it simple. I mean, some people like to put in formulas based upon number of hours and period of time and all different kinds of things, which gets very fancy and not great. So I wouldn't be screwing around with that. Third, and this is probably the one that I've seen the mistake made the most often, which is that it's really important. I mean, the people who created the idea and the invention and all that, I mean, it's really important. It's critical. But for that, there would be no company. I get that. But you really need to incent people going forward. And so the people that are going to drive the company going forward is really where the bulk of the equity needs to go. Now you can invest it over time, which we'll talk about. So if they get, you know, the one people just walking away with a lot of equity who were going to do it but don't do it. But you want to sort of weigh on the side of people who are going to drive the value going forward. Really important. The next bullet point is my favorite, which is when you think about how many founders get, what founders get how much. The wrong approach is to, oh, this is easy. Take the number of founders that want to divide 100% by the number of founders, and that's how much it gets. And everybody gets even Steven. That was an easy problem. Why are you even spending time on this? That may be the answer, but that would be pure coincidence. Because it depends on what value they've brought, what value they're bringing going forward, what value they're giving, what it takes to incent them. So just dividing by giving everybody an even amount often is not the right result. And actually, I would dare say is typically not the right result. And then you'll see that, you know, often people come into my office, well, this is easy. There's two of us, 50-50, be done with it. And the problem that asks all kinds of questions about the 50-50. And, you know, I'm a lawyer, right? Many of us on the phones are either lawyers or law students. And so we are trained to ask, what if? So what happens if the two of you can't agree? What happens if there's a deadlock? What happens when you can't stand each other, right? And if it's 50-50, who makes those decisions? And so 50-50 is a problem. Now there are some ways around it. You can have what's called a shotgun provision, which is to say if it's 50-50, and shotgun sounds way too violent. It's simply a mechanism for divorce, which even sounds bad too. But what it means is that somebody throws up a number and the other side has a right to either buy or sell at that number. So you have to be really honest because you don't know whether you're buying or selling. That's a shotgun provision. Sometimes you have a third party, you say, okay, but we're gonna have a third party director. So a third party is a director. And so basically they're being a arbitrator, or you can send things to arbitration. That's all fine. It's better not to have 50-50 in the first instance. That's sort of my bottom line there. You know, sometimes we do it when I'm a little less concerned when I know that, for example, you're about to take additional equity. And so this 50-50 is only going to be like for a couple months because you're about to get an angel investor. They'll put somebody on the board. And so this is only an amazingly confident this is a very short period of time. Then I don't, you know, I wouldn't spend a lot of time worrying about it. So there's something called the Bemworth Founders Pi Calculator, which you guys will spend a little bit of time on in connection with the roadmap. It is not perfect, but I have found over time that it is a nice mechanism by which to have an honest and open discussion with each other about the relative contributions of each of the founders. And it actually, when you go through it, comes up, it's not perfect by any stretch, and I think Frank Demler, who created this, would agree with that, but it creates the dialogue and actually gets you pretty close. So let's tell you how that works. And what you do is you look at the relative contributions, you weight them, and then you look at the relative contributions, you weight them, and then you figure out what percentage. And the five that we sort of come up with, and there may be others, is the idea, business plan, domain expertise, commitment of risk, and responsibilities. These are five examples. So let me give you an example of how this would work. Suppose we've got four founders sitting around the room. One's the inventor. He's the leader in the domain. He's the guy. You got a business guy. So you happen to recruit an MBA who's going to take MBA students who's going to give up his job at Google and spend full time on this, perhaps even giving up his salary in order to drive this forward. You have the technology guy. He was the inventor's right-hand man who's not going with the company, but knows a whole lot about this and can consult perhaps going forward. And a research team member who happened to be with the inventor, understands it, but really no role going forward. So I can weight these. And And maybe I think that the idea is really important, and the commitment of risk is really important for that because somebody's actually going off and going to give up their career to do this. So I give each of those a 7. The business plan, I can pay people to do a business plan, so it's not as unique. So I'm going to give that only a 2, and you'll see I give the others some weights too. And again, there's no magic to this. This is subjective, something you do. All right, then we took at each one of these. Okay, so how from 1 to 10, how am I going to scale these for each one? So obviously on the idea side, the inventor got a 10 because it was all his idea and he's the brilliant one, and a little less so for the business guy and the technologist, etc. The business plan, the business guys, he's going to do the bulk of that, so I gave him a big fat 8 for that. The commitment of risk, the business guy got a big 7 for that because he's the one that's jumping off with it. And you'll see the responsibility going forward, and 6 for the business guy, and you'll see the rest of those filled in. Okay, so then I crank it through the math and multiply it out, see how many points they get, and you'll see that when you get all through that, the inventor got about 33%, this guy got 44%, technologist 16%, and the researcher 6.2%, adding up to 100%. If that adds 110%, by the way, don't do that. Just joking. You can't get more than 100% because then you go to jail. But actually this is not a bad. I mean, that. Who's doing what? Who's bringing what to the table? And what's your role going forward? So it's not bad. There's once you allocate it, I want to spend one moment on this on the equity arrangements because it's really important that the founder's stock vest over time. As I mentioned, and I said it in a sentence, but I want to spend one more moment on it. It would be a shame if Oded and I went on this when I started this new company, and the day after we did it, I gave Oded 50% of the stock, and then the next day he left with 50% of the company. That would be really a shame, at least for me, not for him. So what we do is vest over time. So even though you only get a certain amount of your stock over a period of time, called 3, 4, 5 years. And if you leave before then the rest of it, you don't get the rest of it. So you want to think about the period of time for vesting and the amount that vests over time. Sometimes you have a buyback right. So even if you can buy back vested stock, so even when they leave, they sell back the stock that has vested over maybe at the fair market value at that point. On a theory that they shouldn't even have the interest going forward after that. I want to take that percentage and give it to somebody else who's going to drive the business for that. So they should get the benefit of the value from the time they came in to the time they leave, but not beyond that. So that's worth thinking about. So not that, and sometimes we compromise and have some percentage of it be bought back, and some they keep some piece so that they, and so they have what we call SMUC insurance, which is they own. If this becomes the next Google, they have a piece of that. And
David,
think about the term. Yes.
Just if you could expand on fair market value, my experience is a lot of agreements that go south up on fair market value. So if you can come up with a pre-agreed upon formula while everybody's smiling at each other, solves a lot of the valuation issues, down the road. A simple multiple of EBITDA or revenue, or an average of the two, or something like that. Can you speak to that a little bit?
Well, I think that's right. I mean, to the extent that you can agree. I mean, there's there's a couple different ways to approach fair market value. One is to say, okay, we're going to allow an appraiser to decide. Right? And so you have a very fancy mechanism to determine who's going to decide. So you figure out who appoints an appraisal, and it's usually somebody like an accountant or somebody like that to determine at that time. So that's one process. A second process is to come up with a formula, have a formula, as Dawn's talking about, which is a percentage, a multiple of EBITDA, which is earnings before interest, taxes, depreciation, and amortization, or a multiple of revenue, and that kind of a thing. That doesn't work in the case of a pre-revenue company. That kind of formula, then a zero. But you can do, for example, an amount that was of the investment, or sometimes you can base it on if there's a valuation I'm sorry, if there's a investment, you can do it on a fraction, percentage of the investment, because it's presumably it's preferred stock, so you can value the common stock or something like that. So you can base it upon the previous investment. But the point, I think, is to have a discussion about how that value will be determined when you do this, and think ahead as to how you're going to do that. So there's a clear understanding on how you're going to achieve that valuation. And I agree with Don that if you're looking at the number of fights later, it's often on that very question, evaluation.
Thank you.
All right, so we got to clear the founders, allocate equity, and talk about the covenants, choosing vesting. Questions on that before I move on to the final one about operational considerations?
Can you put a condition on the options, like how you transferred the equities, the founders' equities, when this terminate, when the founders no longer with the company?
So ask that one more question. If they're no longer with the company, put restrictions on
how
selling the company?
the founder could maybe assign a share to somebody else or transfer to.
Absolutely. So absolutely. Actually, we often put restrictions on transfer of stock in the shareholder agreement or operating agreement. Shareholder agreement with respect to corporations, and operating agreement for the limited liability company. And you restrict the transfer of stock because you don't want some stranger, perhaps a competitor, to own the stock. And so even before they leave, even while they're still with the company, you often and almost always put some kind of restriction on transferability of the stock. And usually it says that without the consent of the company almost always has a right of first refusal. So even if you permit it, you give the company their opportunity to buy it first. But yes, you want to put restrictions on the transferability of stock. Cool. Good question. When you get to this, one of the things that I think it's really good to have a honest and open discussion about who's going to call the shots, right? Who's going to be on the board? Who's going to make those decisions? I mean, it doesn't need to be as official as who's on the board, but who's going to make the decisions? Who's going to appoint the board members? Are all of you expecting to be on the board? Do you not expect to be on the board? Did you want a majority? Do you want a supermajority? Who's going to call these shots? And I kind of like to have that honest and open discussion beforehand, because I don't want people to be surprised later. And so it's important to have. And I always joke that when I was in law school, one of the first things I learned was the most important question is who decides who decides. And so who decides who's on the board making the decisions. Sometimes you have, I talked about supermajority, sometimes you have significant decisions that require supermajority, which is there's three of you, maybe it takes two to decide to sell the company. It takes two to decide to take additional equity. Maybe it takes two to decide to whatever. But the point is that it takes two rather than just a majority. Or maybe the better example is four founders requiring 75%. It takes three of you. So I mean, just figure out how many it takes. So that's worth thinking about. And we often have what's called supermajority provisions, which requires a supermajority, 67%, 75% to do it. If there's multiple people, even three, the one thing I try to avoid is unanimous decisions, and especially if you get to four founders. Avoid things that require unanimous, because I've been held up too many times in my life by unanimous. That fourth one or that last one is very expensive, that last consent. So if you have multiple founders, as an example, you're going to have a shareholder agreement, or you're going to have an operating agreement. It's good to be able to amend it with less than all of the members, all of the shareholders. Employees, one of the things you're going to talk about in this roadmap is what are you going to do with employees? And I talk about severance. You typically don't give severance. I should probably take that off of there. But you want to make sure that in your employees you have intellectual property assignments where they assign the IP to the company. Again, really important. Do you want to impose non-competes on your employees? Some people like it, some people don't, and that's something you ought to sort of have a policy decision up front, or at least think about fairly early. Whether 1 year, year and a half, what's the scope? Are you going to impose that on folks? Because again, you hate to have employees leaving and then competing with the company. And so it's good to think about that up front. I have clients that say, absolutely not, we would never do non-competes. And I have other clients that say, yeah, it's really important. If you're asking me, I think a reasonable non-compete is helpful to the company for significant positions. I'm not talking about the lower level positions, but certainly for decent positions, I would. So that's worth some time thinking about. And I'm not going to go through the types of employee equity at this point. I will say, I mean, we're going to talk about the types of equity, but there's options and profits and trusts, all of which I think is beyond the scope of this. But the question is, how much equity do you want to give to employees? And one of the things I always tell people about how much equity to give employees is, remember, it's not candy. The point of giving equity to employees is to attract and retain good employees and good talent. That's the reason. If it's not necessary, don't do it. If it's not effective, if it's not accomplishing that, don't do it. Not every position merits or should have equity. If you give employees equity, it should vest, much like I talked about with the founders, it should vest based over time. Some people do performance-based, which is if you have a salesperson that you're giving equity to, maybe they do it based upon performances hitting milestones. But it's really, but at least time-based vesting. And a repurchase right, a little like I talked about with the founders. You want to be able to, I mean, you ought to be able to buy back their stock when they leave the employee of the company, even vested stock at then fair market value. And Don, on this one, I typically say in mine, as determined by the company, it's sole and absolute discretion, because they pay for it, and so I'm basically taking it back as a company determined evaluation. And again, this can be controversial, so let me spend one moment on it. Again, the theory is an employee should get the benefit of the value of the company from the time they come to the time they leave. They shouldn't get the value after that, so to buy it back. I already talked about that. So that's the employee equity amount investing. So you're going to talk a little bit about governance arrangements, directors and officers, who appoints them, what kinds of arrangements supermajority requires. Are we going to have restrictions on transfer of ownership? And my view of that is always, maybe a right of first refusal, and maybe they can't transfer it without approval of the company. Think a little about how much equity. I will tell you that a rule of thumb is for technology companies is like 15%. Just the equity is sort of put aside to an option pool. It varies greatly, and there's some that are less, some are more. But just if one's looking for a rule of thumb, that's a typical rule of thumb. And a vesting period is often something like 3 to 4 years.
So David, this question comes up that at the time when you're doing the Frank Demler, how to break it up. And so let's just say one founder gets 60% and the other gets 40%. But should, at the time of the company formation, should you be setting aside the 15% for employees? So it's really not 60-40?
You don't need to at that point. I mean, you can adopt the option pool later, but just know that 60 and 40 are both going to get reduced by 15% each on a proportionate basis. But there's no point in spending the money or doing the brain damage to adopt an option pool until you're ready to hire employees. Just know that when you do it, you're going to get diluted. And part of the reason I say this is because you may decide later to have a different kind of equity. So I don't subscribe to the theory that from day one you quickly put in an option pool. I usually suggest that you wait a little bit until you're ready to start hiring employees.
Can you restrict Elon Musk share to be transferred to his or to his future wife?
To his future wife?
Yeah.
Good question. Really good question. So you can. So you can certainly do that. And you can say that you may not transfer this to your spouse, and it's only your individual name. The fun question related to that is that if your founder or an employee gets divorced, will a court, the divorce court, impose a sort of split that and basically force the transfer, notwithstanding what your agreement says? And what we have in our typical agreement is that if that happens, then the company has a right to buy that stock, so it doesn't end up in a spouse. Usually, when you do that, you have a spouse sign a piece of paper that waives any spousal right they have as a community in California, for example, community property, or elsewhere, and waive that right going forward. So you have a couple protections. One is they don't put it in their name. Two is they waive the spousal consent. And third, if they do end up with it, you have a right to buy it back. If you do all three of those things, the probability of ending up with a spouse as a shareholder is pretty low.
Thank you.
As you can see, I've never had that problem. Just joking. Go ahead. Other questions?